Reasoning. How did the court arrive at this holding? Was it applying or overruling precedent? Often trying to follow a judge's application of law to facts can seem like a treasure hunt. She may not announce her reasoning boldly. She may disperse it through the opinion. The facts may be ambiguous. The lines separating a judge's holding, reasoning, and dicta are rarely distinct. For example, the court found for Dudley Guilford because of the free and easy hospitality which exists in New Haven at reunion time, and which apparently places a special burden on Yale to foresee the muddle headed peregrinations of every inebriated, weak bladdered alum. But just how the university felt to meet this burden is never really spelled out in the opinion. Understanding a court's reasoning involves two analyses: one, the judge's own logic and conclusions, and two, uh, his use of earlier judges' ideas in the form of case citations. A court that wants to get around a previous decision can read it narrowly, focusing strongly on the specific facts rather than the opinion's underlying logic. Courts occasionally reinterpret the reasoning of their predecessors, supposedly, but not really, without disturbing previous holdings or reasoning. At the other end of the spectrum, courts seeking to apply a previous ruling expansively may generously ignore significant factual differences or treat language that is quite plainly dictum as if it were part of the earlier holding. And the variations go on. Most often, courts choosing to apply precedent will remain true to the earlier case's reasoning and distinguish it only when the facts are different in a legally relevant sense. But don't be too sure. Dissents and concurrences. More than one judge listens to each case brought before an appellate court. Judicial minds do not always agree. Accordingly, do not be surprised when you find that many of the opinions you read are not unanimous. The majority opinion speaks for the court and expresses its holding. If a judge agrees with the majority's ultimate outcome, but not its reasoning, she may write a concurring opinion explaining her differences. Disagreement with the majority's outcome, and possibly, though not necessarily its legal reasoning, is expressed in a dissenting opinion. While neither concurrences nor dissents carry formal precedential weight, they are frequently influential. Legal doctrine is always changing. Superscript 4, it reads: lawyers use the word doctrine to connote legal rules and principles. Black letter doctrine refers to those fundamental meat and potatoes aspects of the law that have gained widespread acceptance. Returning to the text. Today, the majority prevailed. No one can be sure about tomorrow.